Paul, are you there?
I am here, my lady, but it does look like Mr. Davis is offline now.
Okay, let's just give it a few minutes. He'll probably come back.
Thank you, my lady.
He is back. Okay, Paul, please call up the matter.
Thank you, my lady. As the court pleases, my lady, this is a matter between the Special Investigating Unit and Mr. P.K. Lehodi and two others by LP01 of 2020, appearing in the Special Tribunal of Africa for Madam Justice Mudiba, 20 November 2023. My lady.
Thank you. Counsel may place themselves on record.
May it please the court, my lady, I appear on behalf of the first and second excipients, together with my learned friend, Carel Schmal.
Thank you.
May it please your ladyship, I appear on behalf of the respondent, together with my learned friend, Mr. Janse van Rensburg.
Thank you. Yes, Mr. Davis.
May it please the lady. My lady, the general principles pertaining to exceptions are well known. They've been set out, and I don't intend to traverse them in any great detail. The important aspects are replicated in most of the claims. My lady will see that there are claims in broad terms, but those claims are then broken up into various alternative claims attributing liability to the different parties. It is the problem is that these various alternatives do not sit together, and moreover, the general manner in which the case has been pleaded has been in of the actual detail as to, amongst others, wrongfulness and damages, as would render the claim either not displaying a cause of action or alternatively vague and embarrassing. The prejudice which the excipients suffer flows from the nature of the complaints and is indeed supported by the case law, which I will refer to in due course, my lady. Without further ado then, my lady, I would like to refer you to the amended particulars of claim. Those are the particulars of claim served on the 4th of October 2022, which my lady will find at section 85-1. This document is the result of a painful evolution that we respectfully submit has not yet reached its final destination as an acceptable claim as contemplated by the rules of court. And here the starting point is, of course, Rule 18.4, which requires that the plaintiff must set out its case, or the pleader must set out his case with sufficient particularity as to enable the party to respond. And then 18.10 is in similar terms, but the wording is important. It refers to enable the defendant to, or the other party, to assess the quantum thereof. And I would emphasize those words, assess, which inquires a critical, or implies or requires a critical analysis of the facts pertaining to damages. My lady, if I can take the Honourable Court to the amended particulars of claim, and in particular, Claim 1, which starts under section D, page 85-9, and it sets out initially a series of events that resulted in allegedly an overpayment or loss in the amount of 3 billion or more, which the SIU would like to claim from our clients. The allegations pertaining to the first excipient, namely the second defendant, Schmal, that Milady must turn to (85-14). Already we see a problem at paragraph 31. Is Milady with me?
Yes, I'm with you.
31 starts off, it's an alternative claim, but it starts off by saying that Lachori occupied or owed a duty of care. And then it carries on with paragraph 32. Milady will recall that this claim pertains to the relatively small amount of 90 million, and that was the original motion that was submitted by the defendants. The exception complains that, if I can paint in broad brushstrokes, that the claim relies with impermissible vagueness upon unspecified statutes and standing orders and the such like. The vagueness also extends then to damages and wrongfulness, and I will take Milady through starting at paragraph 32, where it is alleged that the second excipient, in submitting the motivation for the deviation, performed certain acts. He apparently ignored, and if I can take Milady through these positions, the first, through these statutes, the first few are absolutely meaningless. Section 217 is the broad overarching statutory framework for tenders and state action, whereas the PFMA deals with the responsibilities of the officers and such like. It gives a range of duties. It is not just one standalone section. And so to section 2 of the PPFA, it simply refers back to the constitutional obligations. And what we are left wondering with Regulation 16A of the Treasury regulations, we don't know what part of those Treasury regulations we have supposedly infringed. We have the Treasury practice notes, which are likewise voluminous documents, and then an entire supply chain management policy manual. Milady, important aspects of pleading regarding a breach is that it is essential that the pleader should be able to identify exactly which statutory provisions one is relying upon. And the erstwhile appellate division made this absolutely clear in the well-known case of Yanoko versus the Pro Club, which is in my heads of argument. It refers to older rules, but the situation remains the same, as I will show in a moment. At 623 F to G, the by now try principle is stated. If the pleader relies on a particular section on a statute, he must either state the number of the section and the statute he's relying on, or formulate his defense sufficiently clearly so as to indicate that he is relying on it. So we have no idea what is the conduct that offends against the standing orders or the treasury notes or the list of subordinate legislation or indeed ordinary legislation that has been advanced by the plaintiff in his particulars of claim. So if I can take my lady to the judgment of McCreath in Trope versus the South African Reserve Bank, my lady will find that this case, in our respectful submission, is determinative of this exception. It deals with, in broad terms, how pure economic loss should be pleaded. And in these circumstances, it is under the lex aquilia, but the same principles as to damages apply. So the starting point, as we've emphasized in our heads of argument, my lady, lies in the endorsement of the age-old principles that the opposing party must have a full and proper grasp of the case that it is to be met, as stated in Trope at 211C. It cites Leviton, which is also in my heads, where it is made clear it's not just a question of can you plead, because the simple question, because you can always deny, you can always plead. So the court makes it clear that this is not the only test, and it is stated that if that were the only test, the object of pleadings to enable parties to come to trial prepared to meet each other's case and not be taken by surprise may well be defeated. And the court continues, thus it may be possible to plead as particulars of claim, which can be read in any one of a number of ways by simply denying the allegations made. So that is the retort of anybody opposing an exception. Likewise, to a pleading which leaves one guessing as to its actual meaning. Yet there can be no doubt that such a pleading is excipiable as being vague and embarrassing. And the Parolands case is likewise good authority. And the important bit is, it follows that averments in the pleading which are contradictory and which are not pleaded in the alternative are patently vague and embarrassing. Now that will have specific application to certain of the alternatives where the where the plaintiff incorrectly and in contradictory fashion pleads that but for the conduct of the excipients, then the unlawful conduct would have happened in any event. And that, my lady, is completely inimical to the existence of the claim and completely contradictory to the balance of the allegations. So just from that point of view, we already have changes that need to be made in order to transform the present document, particulars of claim, into an acceptable and non-contradictory fashion. So I've cited there the some general principles relating to prejudice, and also what the Honourable Court has had to say about the about contradictory averments. In that context, my lady, if I can then return to the particulars of claim. The first problem that arises is that the excipients, or particularly Schmal and Killian, they submitted a deviation. Now, here the question is, but who did what? And from a pure common sense point of view, what we really need to ask ourselves is the following. Is the submission of merely submitting a motivation, which then has to be decided by some other party, does that, the submission of a motivation, in what way can that possibly give rise to what is in essence a delictual liability? They submitted a motivation. Nothing more or less is said than that, but I would respectively ask the question which must be foremost in the Honourable Court's mind. Why is a motivation in the amount of 90 million rand, why does that, in and of itself, why does that amount to loss or damage to the department? We don't know from any of the statutory provisions. We don't know from any allegations as to conduct why the 90 million constitutes damages. So there's a causation problem and there's a damages problem. The way this has been pleaded, it is simply not possible to know how this, if I can take my lady to paragraph 35.8 on 85-18, you see the allegation of loss or damage in the amount of just short of 91 million. Now, why is that loss or damage? It is not alleged and it certainly doesn't appear from the balance of the other claims insofar, and this should be a standalone claim. Claim 1 must be perused for the purposes of this exception as unless there are specific other paragraphs that are incorporated by reference, this claim is standalone, and it doesn't. The important thing to notice is that none of the sections that have been cited by the plaintiff in terms state that there is any liability in law on the part of the functionaries. And certainly this has not been alleged. So certainly we would contend that there is no proper pleading of the damages as required by Rule 1810. What is also a problem, and I've hinted at the fact that the whole question of authorization should have been pleaded properly. At paragraph 45.3, which is in respect of claim 2, we see that the allegation is made against Mr. Lachodi that he misrepresented a report to National Treasury, and he misrepresented at 45.3 that there was an authorization given for works in the amount of 2.2 billion, when in fact, I'll quote, when authorization was given for an amount of approximately 91 million. So that amount of approximately 91 million is clearly the amount that is referred to in claim 1. But the problem arises with the way that claim 1 was pleaded, in that it does not say what happened to the authorization. It does not say what is the problem with the motivation. Now, the motivation must be in the nature of a representation. It is a motivation representing that certain things are required. Now, the elements of a negligent or fraudulent misrepresentation are nowhere to be found in claim 1. All we know is that a motivation was submitted to whoever must approve it, somebody higher up, and it is alleged that there was damages of just short of 91. In law, I respectfully state that it cannot be the case. The particularity as to how this liability arises is missing, rendering the claim nugatory as not displaying a cause of action. At the very least, it is missing essential averments that prejudice the excipients, who are entitled to know exactly what it is alleged about the motivation that caused damage, notwithstanding the fact that there was obviously a process. Now, the importance of these administrative law processes goes also to wrongfulness, as my lady will see in some of the other claims. But for instance, where a tender is awarded, the courts have made it quite clear that you have your remedies. If you don't like the tender, you don't just sue the tender board. You appeal. You follow your remedies. It is over and above the statutory arrangements that an indication of wrongfulness must be demonstrated, and this has not happened in respect of claim 1. the conclusion that either Mr. Schmal or Mr. Kilian are liable in law is not sufficient, as stated at paragraph 36. There is nothing pleaded that brings the conduct of either first or second excipients within the ambit of any of these, this plethora of legislation that is referred to. There's nothing to indicate why the motivation itself is in any way offensive. Conclusions are alleged. It's a breach of this. It was reckless. It was failed to comply with or ignored unspecified standing instructions. But what those instructions are and what the infringing conduct is nowhere to be discerned in Claim 1. Now, it has been suggested that the excipient confuses fucked up probantia with the fucked up probans. However, to say that somebody failed to implement a supply chain policy is a conclusion. What must be alleged and proved is the conduct that justifies the conclusion. The smaller detail of how, where, and when that may have happened, that may, in some circumstances, constitute factor probans, but the probantium with, say, negligence does not start and stop with the conclusion of recklessness. If you will say that somebody is reckless, you must say why their conduct falls short of the reasonable man, or what they knew, what they could have foreseen, what steps could have been taken to avert the harm. Those are the standard allegations where one has an omission, and if there are positive acts amounting to negligence or fraud, then the acts must be pleaded rather than simply reliance on subordinate legislation or legislation without showing the concomitant conduct that infringes that act. In particular, it is completely unclear why the mere submission of a motivation could give rise to a legal liability, as it's phrased, in the amount of just short of 91 million. Milady, the points as to damages and wrongfulness arise also in Claim 2, and I will deal a bit more with the authorities that are equally applicable to Claim 1 as we go along, if it may please the court. The Claim 2, milady, will find at 85-20. It also has various alternatives. It is, however, a much bigger claim. It is for 3 billion rand, and it is based on the amended appointment letter, which allegedly gave rise to further damages. The allegations as regards the first and second excipients milady will find at paragraph 55 and onwards. Here again, we have what I've referred to as the Yanuko problem. It is, of course, stated more fully in Trope versus the South African Reserve Bank. And milady will note that Trope has been followed. It is, in essence, a locus classicus on exceptions. The allegations against Kilian, if I can just quickly refer my lady to that. There are the facta probantia justifying conclusions of recklessness or intention. They are not there. The what provisions of the supply chain management was not complied with, or how unspecified standing instructions, what they say or what we did to transgress them. All of that is simply not pleaded. What we do have is simple allegations of failure to prevent loss under circumstances where it is not clear what could have been done to prevent this loss, whether the loss was foreseeable, and whether there was, in fact, a duty of care. So if I can refer to Trope again at page 217E of the judgment, the learned judge deals with contradictions and particularly state of knowledge and pleading contradictory facts. So I must start, my lady, at page 216, where it is specifically pleaded. It would appear at 216G that it is alleged that the registrar had a common law duty to prevent persons whom he knew to be unlawfully conducting the business of a banking institution from doing so. Now, the comment of Judge McCreath comes at 216I. He says, no specific facts have been pleaded to substantiate the allegations in paragraph 22.6, which I've just quoted, that the registrar, by virtue of his position as such, had a common law legal duty to prevent what is alleged in this paragraph. The facts that give rise to the legal duty must be clear. The judge continues, nor is it clear whether reliance is placed on the provisions of the Banks Act, to which reference is made in paragraph 22.1. If so, then for the reasons stated earlier in the judgment, it was incumbent on the plaintiff to specify the relevant provisions on which they rely. And if other facts are relied on, then they should be pleaded. However, at present, there is an ambiguity causing prejudice. As far as paragraph 22.7 is concerned, the ambiguity surrounding the use of the phrase I beg your pardon. So, milady, that portion of the judgment deals with the wrongfulness. that there are not facts as would demonstrate that wrongfulness. And then I mentioned 217E while I'm here, and I will show where this situation arises in a moment. But the Honourable Court seized upon a phrase that, and that as a consequence of the first defendant and or the registrar's negligent conduct, plaintiff suffered damages in the amount set out in paragraph 4, less any other amounts, ... which damage the plaintiff would not have suffered but for the first defendant or registrar's negligent conduct. Then, elsewhere, other negligence is alleged to have caused the damage, and those two different statements are obviously wrong then. I will take my lady to the but-for defense, or the but-for statement appears at paragraph 59. Of the particulars of claim, that's 85-26. Had it not been for the actions or omissions by Lachori and Kilian, LTE would have been unlawfully appointed in the amount of 2,211,000,000. Does my lady have that spot?
Yes, I am with you.
Now, the critical thing to observe of that paragraph, and this but-for paragraph appears later in the particulars of claim as well. Had it not been for the actions, so despite whatever Schmal and Kilian did, LTE would have been unlawfully appointed.
But doesn't that appear to be a typographical error, Mr. Davis?
Well, it's repeated, so I don't, but
Maybe
if it's lady, this is
maybe
quite simple.
Yeah.
A typographical error, no. And incorrectly expressed, perhaps. It's the wording is just a bit funny, but it is more incorrectly expressed than a typo. But to answer the question, my lady, insofar as my lady is suggesting that one can just read it in a different way to what the express wording says, that would be completely contrary to what is said in trope and other cases about an ambiguity. That's something that on a proper reading can be read two ways. This is not ambiguous, my lady. This is absolutely crystal clear in terms of the express meaning of the word. What my learned friends for the SIU want to say is, well, it's just a typo. Read it for what it should read. That is contrary to trope. It is the court drafting pleadings for the parties in defiance of the express language that they have chosen to use, which they have repeated in the particulars of claim, and which, if it was a typo, it would be the simplest thing in the world to just change, it's not a typo, just change the wording. If that was the problem, then change the wording. It's important that this contradiction can't stand, because it is a salient part of this particular alternate claim against Mr. Killian. The liability, it is simply alleged he is liable to payment of the amount set out there under, and that's at paragraph 58. And then at 59, we have the contradictory assertion that LTE would have been unlawfully appointed in any event. And it's immediately followed by paragraph 60, which again, my lady, will immediately be asking the department or whoever else unlawfully paid LTE and its subcontractors. So there is unlawfulness alleged, but the factual basis of it is not alleged. The contradiction between paragraph 59 and then the conclusion is simply not justified either. Had it not been for the actions, there would have been an unlawful appointment, and then the conclusion that they are legally liable for the excess, let alone the contract amount for the excess, is, with respect, simply unsustainable. Milady, as stated by Justice McCreath in Trope at 217F, once more the plaintiff used the phrase "but for the reasons stated above, and the fact that it is alleged in other paragraphs of the particulars of claim that it is a consequence of the second defendant's conduct that the plaintiffs deposited money with Vermaas, a certain fraudster, then the same ambiguity arises as that in regard to paragraph 19 of the particulars of claim. That should be cured, says the judge. And I respectfully submit that if it was really that simple as to change an imperfect manner of expression, Milady will agree, then a simple amendment would have saved this particular alternative claim. If Milady will just give me a moment. I will perhaps refer at this point to the judgment in Levitan. I beg your pardon, Milady. No. Milady, once again, the problem with damages is abundantly clear. The third claim is against the first and third defendants, namely Lachordi and Kilian. And again, we have the recurrent problems. We notice that it is in respect of refurbishment and repair of Gianni. And we also know at paragraph 64, Milady, that the SIU have all the information at their disposal. And here we see that this claim is basically to do with a failure to get Treasury approval for the additional expenditure of a further 1 billion over the 2.2 that LTE was contracted for. We see calculations down to the last cent. However, the claim does not identify which portions of the works done by LTE as a total of the of the additional 1 billion. There is no indication of what was usable, what was not usable, the standard of the workmanship. But more importantly, it is unclear, again, what the wrongfulness of particularly Mr. Kilian is. What did he do that resulted in a further billion being paid? We know that there's lots of statutory and subordinate legislation out there. There's tons of it, but we don't know where in those tons should we find something that suggests that Mr. Kilian is somehow responsible for this situation. The same problem as with damages throughout. I've mentioned it in respect of claims 1 and 2, and the case of Nasionale Aardappel Koöperasie versus PricewaterhouseCoopers makes it very clear what needs to be done. We know that 18.4 provides an injunction to plead with clarity so that the opponent knows your case, but it goes further than that. In 1810, Rule 1810, more is required. And if I may refer, my lady, then to the judgment of Justice Southwood in Nasionale Aardappel at 803E. And here we have also, sorry, is somebody talking? I'm not hearing an interjection.
There's no one talking.
I beg your pardon. It must be a noise outside my office. Thank you. So at 8, from 803, the court starts dealing with damages, and at 804, there are particularly 804D. The court continues to point out that there are huge problems in the calculations that can't be overcome without pleading, amongst others, the identity of the debtor, what time periods were at issue, and what performance was rendered and what not. The court continues at E. Paragrawe 6.2 tot 6.2 tot 6.10 van die besonderhede van vordering volg dieselfde patroon en is onderhewig aan dieselfde besware. Hierdie beweringe is duidelik beweringe wat feitelike gevolgtrekkings sonder dat die onderliggende feite waarop die gevolgtrekkings berus uiteengesit word. So, again, we are confronted, as my lady has seen, by allegations of legal conclusions and total liability without the explanations therefore or the factual basis. The learned Judge Southwood continues at 805B. He's talking about a certain paragraph 7, which was what, again, where there were insufficient facts to justify the legal conclusions sought to be reached. And here Judge Southwood says, he refers to Rule 18.4, and he says, gevolglik mis die besonderhede van vordering beweringe wat nodig is om die aksie te staaf. Omdat die beweringe in paragraaf 7 nie 'n wesenlike inhoud het nie, is hulle ook vaag en verwarrend. He goes on to deal with a further paragraph, and it's the learned judge deals with both Rule 18.4 and Rule 18.10, and he says he's basically talking about the complexity of the case and the importance in such a complex matter to plead with greater particularity. And he says, daar is reeds verwys na 'n aantal komponente waar baie groot, maar blyklike globale bedrae onder 'n baie vae beskrywing geëis word, geen leidraad gee wat die verweerders in staat sou stel om nie skade te skat nie. Die eiser het duidelik nie aan die bepalings van reël 18.4 en 18.10 voldoen nie. I respectfully submit that the same applies. Throwing numbers around in the manner in which the plaintiff has done does not meet the requirements of Rule 18.10. But of equal importance, my lady, is further down from 805E, F to G to H, the Honourable Court, citing amongst others Sasol Industries, points out that in such circumstances, the prejudice flows almost automatically. Judge Southwood says as follows at 805G. Die verweerder sal beslis in die vuur van hulle saak benadeel word. Die geskilpunte sal nie volgens die reëls neergelê in die gewystes in die pleitstukke met presiesheid identifiseer en omlyn word nie. Die verweerder sal die feitelike gevolgtrekkings moet ontken, omdat hulle nie weet wat die werklike feite waarop die eis berus is nie. Hierdie massiewe litigasie sal dan voortgaan totdat verdere besonderhede vir doeleindes van verhoor en of deskundige kennisgewings en opsommings afgelewer word. Op daardie laat stadium sal die beheerders dan hopelik weet wat die wesenlike feite is waarop die eiser steun. Intussen sal geleenthede om relevante getuienis en getuienis te identifiseer en te bewaar verlore gaan. Die verweerder sal uiteindelik Die verweerder sal ook koste moet aangaan om die feite te ondersoek, welke ondersoeke uiteindelik totaal irrelevant mag wees met 'n gepaardgaande verspilling van fondse. And that, my lady, is, I respectfully suggest, prejudice, which applies also to the excipients herein on account of the complex nature of the case. And again, with a view on the long history of this case, it is really incumbent upon the plaintiff just to take this honourable court into his confidence and to proceed with a more detailed and carefully motivated and thought through exposition of its cause of action. My lady, I believe I have already pointed. Oh, no, I haven't. If I can take my lady to paragraph 59 then of the particulars of claim, there again we see the but-for argument. And once again, that particular alternative claim simply cannot stand because the but-for argument contradicts the rest of the argument. My lady, if I can move then to claim 4. If you'll give me a moment, my lady. The claim 4, my lady, will find that particulars of claim 85-37. And again, we have the same problem as to the particularity pertaining to overpayment and damages. And once again, we have the same problem with the detail as to the statutory provisions relied upon which the is hard to know. In particular, my lady will be astute to observe that the plaintiff is entitled to know what is their role in causing this damage. It is the department, apparently, that paid. If I can just double check that. Yeah, the department suffered damages. So claim 4 relates to payments made by the Department of Water and Sanitation. That is not the employer of the first, second, or third defendants. They are with the water board, with the LNW, as they call the Lepele Northwest Water Board. They did not pay. What did they do to cause this payment, and why it is their fault in the legal sense? The problem is, again, a question of detail as to who inflated costs, who benefited thereby, what is the value of the work that was done. I pose an interesting question to Milady, looking at the overview of this entire claim. We know some work was done, but what was the quality of that work? How much, what is the value of the work that was done pursuant to this allegedly unlawful contract? That is a fundamental point which reveals that the SIU need to go back to the drawing board and reformulate this claim with the detail that is required, so that we can look at the question of damages, amongst others, in a considered and analytical light, so as to be able to assess the quantum of such damages. As Clutie J said, and I'm looking at footnote 13, Milady, at 496G, there are certain basic principles, but at 472, at 472B, Clutie J, as he then was, he makes the point that where the damages are not an estimate, and where it appears that the amount claimed for the cost of repair had been calculated to within R3, in that context, the balance of the particulars of claim do not, providing a bold allegation of damages, do not amount to compliance with Rule 1810. The learned Judge Clutie then continued, it was submitted that the amendment would not remove the objection, inasmuch as the cost to the plaintiff of generating electricity itself is not set out. I agree. So in other words, the costs of remedial work are essential then to the calculation of damages, and these must be particularized, as agreed by Judge Clutie. The cost of purchasing electricity from Eskom each month for a specified period is set out in a proposed schedule, as is the amount which plaintiff alleges it saved. But then the judge asked, but what would it have cost the plaintiff to generate electricity itself? I agree that if the plaintiff did not have to purchase the coal, this is a saving that inures to the defendant's benefit and must be taken into account by the plaintiff in the calculation of the damages. So all the components of expenditure, remedial work, etc., must be set out in order to fulfill the purpose of Rule 1810, which is, after all, to enable the recipient of the pleading to accurately quantify or assess the quantum. And in the Sasol judgment, Judge Clutie concludes fittingly that the defendant was entitled to insist that a claim against that particular claim exceeding 6 million, whereas we're dealing with 3 billion, should be pleaded with the formalities prescribed by the rules of court. And the defendant was, in my view, entirely justified in adopting the course which it did. In other words, to object to the lack of particularity relating to the damages. milady, if I can deal also with again, it's the question of wrongfulness that raises its ugly head, and also the lack of particularity as to the damages. With claim 4, we see just a repetition of what has preceded it in claims 1 to 3 as to vagueness, statutory vagueness, vagueness as to damages. I've also mentioned, and I must emphasize perhaps that this applies to all the claims, as I have mentioned, the considerations raised in Eastwell Frankel and MEC Western Cape versus BE. Yeah. If I may be so bold as to summarize, the court makes it clear that that not only must the facts supporting the legal conclusion be set out with sufficient detail as to enable somebody to meet the case or assess the quantum, so too also the question of wrongfulness in the context of administrative conduct must be very carefully assessed. It does not follow, as is made clear in these cases, that a functionary, an administrator, is liable for negligence simpliciter. This applies particularly where a statutory framework makes provision for internal appeals, such as is the case with PAJA. So the important thing to bear in mind is that even the state can set aside its own tenders, its own contracts, its own dealings with third parties based on PAJA, based on the alleged wrongdoing of its own functionaries. However, that does not follow that the functionaries themselves can be in delict unless there's a clear intention from the statute. What my learned friends have not done for the SIU is approach this court on the basis of the promoted trust, which also provides for damages in exceptional circumstances. And it is the exceptional circumstances that is a common thread running through liability of state functionaries. Flow, the mere fact that they were negligent does not make them liable. And in particular, the wrongfulness of the conduct must be specifically pleaded and proved. Milady, could you give me 1 minute? I believe it will shorten the proceedings somewhat. I just need to collect some paper from an adjoining desk. May I please support? Milady, thank you. I am satisfied that I have set out the outline of the plaintiff, of the excipient's objection, and I will address the court further in reply to the extent necessary. Is there anything my lady would like to hear me on at this point?
No, thank you. No, thank you. To break for tea. We will resume at 11:30.
May I please?
Sorry, my lady, was that 11:30?
11:30, yes.
Thank you, my lady.
Thank you.
Thank you, milady. Milady, may I just check whether the systems are working? Can your ladyship hear me?
Yes, I can hear you loud and clear.
Thank you, milady. Milady, as is my wont, I do not intend simply to read through our heads of argument. Should I not deal with anything in the heads, it of course doesn't mean that we abandon the argument. It would simply be prodigal of your ladyship's time if I were to read the argument. It gets no better for the telling. Milady, may I commence perhaps by criticizing, and when I say criticizing, I don't mean it in a denigratory fashion, my learned friend's approach to the argument on behalf of the excipients, and indeed the exception taken to our particulars of claim. My learned friend commenced his argument by saying that the law relating to exceptions was trite. Yes, indeed, it may be trite, but my learned friend then embarked on an exercise which is absolutely counter to what the trite principles are. Perhaps the most important principle of all is that the particulars of claim must be read holistically. It must be read as a whole. What my learned friend embarked upon was a cherry-picking exercise, taking out particular paragraphs and suggesting that these paragraphs rendered the entire particulars of claim vague and embarrassing, or as not disclosing a cause of action. Let me illustrate. Perhaps the best illustration of the approach adopted by my learned friend is this. May I ask your ladyship to turn to case lines page 085-15.
I'm there.
My learned friend boldly asserted that the first four items of legislation, that is 32.4.1 through to 32.4.4, were irrelevant and did not assist his clients in being able to identify which statutory obligations they in fact ignored or omitted to apply. But what my learned friend did not read to your ladyship, first and foremost, is, if I may ask your ladyship to turn to 085-7.
Yes, I'm there.
You'll see that we have pleaded here under the rubric authorities the following. The relevant legislation for the purpose of the plaintiff's claim are the following: national and regulations, the Constitution, the PFMA, the chapters we give, the section. We give the Treasury regulations published under these government notices and government gazettes, 15 March, issued in terms of Section 76 of the PFMA, the PPPF Act. We give the regulations 2011, published under government notice, commencement date 7 December. Insofar as the Water Services Act is concerned, we actually, in Annexure G, 35.1-83, give the directive which the Minister issued, and I don't think it's necessary for your ladyship to refer to it now, but just make the note, if you will, please, my lady, 35.1-83. Then the SCW, the policy dated 2013, so we identify it. Then National Treasury Instruction. Over the page to 085-9, National Treasury Practice Note 32 of 2011, National Treasury Practice Note 6 of 2007/2008, National Treasury Instruction Note 3 of 2018-2017, and Practice Notes and Guidelines issued in terms of 76 of the PFMA. Now, Milady, may I return then to that part of our pleading, which my learned friend criticized as being irrelevant and which gave them no guidance as to the omissions which their clients are accused of. If I might refer you, by way of exemplification only, because I can't read all of these sections, and that's why we didn't repeat the entire section in the particulars of claim. This would have been a document of a few hundred pages. Let me refer to section 57 of the PFMA. It's 32.4.3. Milady, I can't put this up on the screen for your ladyship, but I'm going to just read it to your ladyship. 57 of the PFMA relates to the responsibility of other officials. Now, other officials is obviously other than the accounting officer. The accounting officer, his responsibility is to be found elsewhere. Now, I'm going to read section 57. I don't know if it's available to your ladyship online, but it says this: an official in a public entity, little a, must ensure that the system of financial management and internal control established for that public entity is carried out within the area of responsibility of that official. B is responsible for the effective, efficient, economical, and transparent use of financial and other resources within that official's area of responsibility. C must take effective and appropriate steps to prevent, within that official's area of responsibility, any irregular expenditure and fruitless and wasteful expenditure and any under-collection of revenue. D must comply with the provisions of the Act to the extent applicable to that official. E is responsible for the management, including the safeguarding of the assets and the management of the liabilities within that official's area of responsibility. So when we say these are your responsibilities, we ask the court to read into 57, obviously what 57 says. And it is unnecessary for us to repeat and generate reams of paper each of the subsections of all of these sections. We identify the section. My learned friend can read through them for himself, and he can consult with his client, and he can plead, and he can say that Mr. Schmal or Mr. Kilian, being the accounting officer, did ensure, was responsible, etc., etc. So there's just absolutely nothing in this argument. It completely misses the point, and what is worse, it ignores the entire pleading by completely ignoring what we call the authorities upon which we have relied. Milady, I may, whilst section 57 is alive and is in our minds, I would like to read to you a judgment in an analogical matter. One of the criticisms which I shall levy against my learned friend's argument is he cites a lot of cases which deal with Aquilian liability, not administrative statutory liability, introduced in terms of the Constitution. And I'm going to demonstrate to your ladyship why those cases on their facts are completely different. This case, which your ladyship will find cited in para 43 of our heads, is the case of Nelson Mandela Bay Metropolitan Municipality versus Petunia. It is a judgment of His Lordship, Mr. Justice Chetty. We say it's analogical because it was a municipality, but of course it's directly analogical because the municipality has exactly the officials of the municipality will have exactly responsibilities and obligations expressed in terms, not in fact, but in terms such as those exist in the PFMA. And this is what Justice Chetty said. The second and third exceptions are similarly without any merit and spawned by disingenuousness. The fallacy in the submission advanced arises from an erroneous understanding of Chapter 4 of the Act. Civil proceedings to recover unauthorized, irregular, or fruitless and wasteful expenditure is an obligation which a municipality is statutorily enjoined to institute. The plaintiff's cause of action is clearly positioned upon the provisions of Section 32(1)(c) of the Act, which provides that any political office bearer or official of a municipality who deliberately or negligently committed, made, or authorized an irregular expenditure is liable for that expenditure. Now, that's exactly what we have in this situation. It is not the municipality that is claiming it back, nor the water board. It is, in fact, the SIU, which is by statute enjoined so to do. So there's absolutely, with the greatest of respect, nothing whatever which is so vague and embarrassing that our learned friends, with studied obtuseness with respect, cannot understand what is being stated here in our particulars of claim in relation to the statutory obligations. Now, I said to your ladyship that I was going to just briefly explain to your ladyship why the cases cited by my learned friend don't really fit the pattern of.
Okay, Mr. Patron, before you do that, I just want to engage you on the submission you are busy making, right? So let's go to the list that you on page. It's on the book. That's
Yeah.
Okay, I want you to keep your thing. In fact, the text starts on in the next page.
Yes, right.
Right? Keep
Yes,
your finger there and then okay, I also like you to open, I think it's 13. Well, it's a number of them. You're taking it to 15, but if that list appears in a shorter form,
Yes.
in a number of paragraphs subsequently, you took me to 15, so 085/15, right? So let's take the first one. Reference to Section 217 of the Constitution. You see that, right? In paragraph 15. Right?
Yes, I have it.
The nation is repeated in a shorter form in subparagraph 32(4)(1).
Yeah. It's section, the paragraph is section 2 Constitution.
Yes. What's the substantial difference between the two? Absolutely no substantial difference, right? The one is a full citation, the other is a shorter citation.
Yes.
We all know what section 217 is.
Yeah.
It's about that should guide public procurement, right?
Correct.
And it also says that a procurement system must be put in that ensures the realization of those values. I'm paraphrasing. Right.
Yeah.
Now, where in the particulars of claim is it alleged that the excipients particularized, or rather, owing to particularized conduct, breached section 217 of the Constitution? Where is it alleged?
Yes. Lady, can I just find it for your ladyship? Milady, could I refer you, for instance, to 085-12?
Yeah.
This happens to be in relation to Mr. Lachordi, but I will find it for you in relation to the others.
My question is in relation to the excipients. Let's not
yes,
deal with Lachordi. He's not here.
32. I'm sorry, milady. 32, para 32, 085-14.
Yes.
Schmal, in submitting the motivation for the deviation, did not invite as many suppliers as possible and select the preferred supplier using the competitive bid committee system, did not invite quotes from as many suppliers or at least 3 suppliers, failed to show that its urgent circumstances, etc., intentionally exceeded his powers by not following the procurement processes in terms of the passage again.
Okay, you will recall when Mr. Davis actually dealt with this point, right? So he said the allegations that involved in the motivation.
Yes.
Submitting a motivation to the allegations made thereunder.
Lady, may I answer? Was your ladyship still questioning me?
You may answer.
It's not a quantum leap because of the principle enunciated almost 100 years ago in Mackenzie versus one another, qui facit per alios facit per se. If you cause somebody else, because of your motivation, to exceed his powers in terms of procurement legislation, because Schmal had a responsibility, for instance, and I'm just using this as an exemplification, Section 57 of the BFMA, to ensure that whatever motivation he included, which would be acted upon, was in fact in terms of whether the causation has been established. And no doubt there will be cross-examination.
I want to go back to section 57.
Yes, lady, I have it.
So you are saying that he was responsible for ensuring that when he does submit the motivation is compliant with the competitiveness value of the Constitution.
Exactly, my lady.
But is that not different from what is pleaded? Because in 32.1, you are saying he did not invite as many suppliers as possible. He selected the preferred supplier.
Well,
he did not invite quotes from as many suppliers, or at least 3 suppliers.
Correct. My lady, may I commence at the beginning? Let us see what Mr. Schmal was. Mr. Schmal was the general manager. I am reading from 085-2. He was the general 085-2, para 3.
Yes, paragraph
3.1. Yes. 3.1. He was the general manager operations of the board, the chairman of the board, and the chairman of the bid adjudication committee. Now, instead of attempting to motivate what we say is unlawful expenditure, by engaging in a lawful procurement process or procedure, he gave a motivation which was clearly
non-compliant
with the Constitution, FMA, etc. That's what we allege. We may not prove it. And it may be that Mr. Schmal has an explanation. He can certainly plead it. He can plead whatever the circumstances were. It is a matter for him to plead. It is a matter for him to rebut when we lead our evidence.
I see.
You see, my lady, there are, of course, exceptions which can be invoked to the proper procurement, emergencies, only a single supplier, and the like. I can't remember all of them, I think, and any of those and plead any of those. But for present purposes, we say his motivation was not compliant.
Yeah, I see.
Thank you, my lady. My lady, may I, whilst we're dealing with that, apologize, because your ladyship is quite correct. There is a typical error in paragraph, I think it's 20. Well, yeah. My learned friend seized on this and even suggested that this the entire pleading excipiable. Milady, if you read it in context, it is quite clear that the word not has been omitted. It should read, had it not been for the actions or omissions by the first, second, and third defendants, LTE would not have been unlawfully appointed in the amount of 90. Quite clear. We apologize for that. But we invoke all of the authorities which say that in an exception you don't peer too closely at the law, and you make the best of it. Because my learned friend is probably correct. Without the word not, there's a grammatical problem. Now, I'm sorry, milady, I don't know if there's anything further that ladyship wishes me to deal with insofar as
no,
the
please
statutory...
respond in full to the argument. That would greatly assist me. Respond in full to Mr. Davis's argument. So in the same way you dealt with the question I asked you around section 217 and whether there's an allegation that that section has been breached. So respond in full to his argument.
Lady, I intend to. I'm not sure that I have the correct order in which he addressed your ladyship. Yes, thank you, my lady. Then, my lady, my learned friend, and I'm going to deal with them in a bundle, dealt with certain cases. I would like to deal with those cases as well, because I will deal fully with his argument. First of all, my learned friend cited Trope's case. Now, the facts in Trope's case were completely different to the facts in this case. Can I just give your ladyship the background to Trope's case?
Yes, please.
In the late 80s, there was an attorney in Pretoria called Thamas who ran an enormous Ponzi scheme, and he was offering interest rates which were quite exorbitant. A whole host of persons in Pretoria, particularly, invested in Mr. Thamas, and literally millions flowed into his bank account in this Ponzi scheme that he had established. A group of persons, of whom Mr. Trope was one, there were about 29 other plaintiffs, took it upon, I might add, one can go and look up the records, but there were a whole host of prominent attorneys, and even with respect, a number of judges, I think, who had invested in this scheme. And what happened is about, I think, between 20 and 30 of the persons who lost all of their money, because, of course, Ponzi schemes implode, realized that Mr. Thamas had no money after the scheme imploded. And what they did is to attempt to sue the Reserve Bank, alleging a common law duty to prevent pure economic loss by closing down Mr. Thamas's business before they did. Eventually, they did pull the plug on him. And the allegations were that the boni mores required the court, of course, before the Constitution, but required the court to find that the Reserve Bank owed a duty of care. There was no statutory duty of care, such as Section 57 in the Banks Act or in the Reserve Bank Act, and it was simply an attempt to extend the common law to pure economic loss in a situation where the boni mores demanded an extension. And it is in that context that Mr. Justice McCreath found that if you're going to, if I can just read the head note, which appears at the reference 1992, Volume 3, SA 208, and it, I'm reading the head note at 208, negligence, action for damages, pleading of Quillian action for pure economic loss, policy considerations and factors justifying extension of action to such a claim. Not necessary or appropriate to plead policy considerations or boni mores, but all the facts on which plaintiff wishes to rely to enable court to decide whether policy considerations or boni mores warrant extension of liability should be pleaded. So those were the facts and the matrix of facts against which Trope was decided. Trope was appealed to the Supreme Court of Appeal, and the Supreme Court of Appeal, whilst being sympathetic, could not entertain it because they said that the upholding of an exception was not in those days a final order which could be appealed. So you'll see that the circumstances were completely different, my lady. And Trope is just no authority for the propositions advanced by my learned friend in a case where there is a constitutional duty expressed in various subordinate legislation impelling a consideration of an official's omissions and commissions where there is fruitless and wasteful expenditure. Lady, my learned friend also referred to Mr. Justice Southwood's judgment in the Potato Board case. And I'm aware that I may not be following his order, but whilst I'm dealing with the cases, let me get them over with. In the Potato Board case, there was a classic allegation of economic loss, and that economic loss had to be proven by expert evidence. And of course, what His Lordship, Mr. Justice Southwood, found was that it had not been pleaded. I'm sorry, I don't have the particular passage, but found that in terms of Rule 18, that there wasn't sufficient particularity of pure economic loss. But here we have a different situation. We are alleging that the award of this contract, first the 90 million and thereafter the extended contract, was illegal, was unlawful, and that in due course we will demonstrate that we trust, and if we don't, well, we don't. And it is open to the court, obviously, to consider whether there has been enrichment. If my learned friend wishes to prove enrichment and plead it by way of a counterclaim, of course he may do so. But at the present moment, the entire amount was unlawful. And that's what happens when a contract is awarded which is illegal. So I cite just those two cases to point out to your ladyship that one must beware when transporting principles from one case to another, where the underlying facts and the underlying statute may be entirely different. Now, my learned friend said that where tenders are awarded, there are administrative law remedies. There may be, but there are also remedies in terms of the statutes. And there is no reason why the SIU cannot contend that, argue to your ladyship, that there is a short fruitless expenditure which the officials, in this case Mrs. Schmal and Killian, are responsible for. Of course they can plead enrichment, and I'm repeating myself.
I actually didn't engage with Mr. David when he made that point. I'm going to make this point. Mr. David noted, because I will need you to respond to it. You didn't refer me to any remedies at the disposal of the SIU. The SIU is acting in terms of the SIU Act. So that argument will be worth considering if you argue with reference to other preliminary remedies at the disposal of the SIU. The remedies you cited would be available to an aggrieved tenderer, for example,
Yes.
And the SIU.
Yes. Yes, your ladyship is absolutely correct. Now, I read the potato case. Now, my learned friend, I think, went from there to claim 4, if I'm not mistaken. And give me, I'm just looking at my notes, paragraphs 90, etc. Yes, that's claim 4. That's all. Okay. Yes, my learned friend, Mr. van Rensburg, points out that we have pleaded in extenso the locus standi of the SIU at 085-3. And we have cited and attached, in fact, and as Annexure A, the proclamation number, and we give you chapter and verse what the SIU is entitled to do. I just want to refer to claim 4. Milady, may I just point out to your ladyship that something that I would like to emphasize is that many of these claims are couched in statutory terms and others are couched in Aquilian terms, but they're all in the alternative. I mean, I would ask your ladyship to see, for instance, 085, no, sorry, that's Mr. Lekhodi. Forgive me. Let me go to Mr. Schmal. Mr. Killian, for instance, we deal with him at para 35 at 085-7. And we point out that at 085-19, we have an alternative claim, which is based upon the common law and a duty of care. That's in the alternative. And then claim 2, ladyship will see that at 085-22, para 47 is in the alternative. Para 49 is in the alternative. At 085-24, that's Mr. Lekhodi again, forgive me, my lady. At 085-26, at para 57, we plead a duty of care in the alternative to the procurement, the non-compliance with the procurement provisions. So that is why one finds the alternatives. And then if we turn to 085-27, we'll see para 63 is again in the alternative. Now, my learned friend argued, he said, well, these parties who are cited here, LTE and its subcontractors, we should seek our damages there. Well, lady, with the greatest respect, where you have joint tort fees, you can seek your damages against all of them. And we will indeed seek our damages from LTE and the others. And if anything is recovered, Mr. Schmal and Mr. Killian have their remedies in terms of the execution process, which can be levied against them if, in fact, our loss has been in any way reduced by an award against these other people. But that's no basis for saying that these pleadings are acceptable because somebody else has also been responsible. A principle in common law that you must first excuse against the company that was unlawfully awarded the tender, none whatever. Yes, lady, I apologize for the fact that we sent to your lady and my learned friend last week a case which I'm afraid slipped our minds, an SCA case, Rumpel Transport. I'm not sure if your ladyship received the case. We didn't upload it because that would have been improper, but we did send a copy to my learned friend and your ladyship, I think by way of email to your ladyship's registrar. I don't know if your ladyship received the communication.
No, I've not received it yet. Mpo, did you receive it?
Yes, my lady, we did receive it.
Okay. Please remember to forward it to me. Thank you.
Lady, I can, if I may interject, I can confirm that I did receive it.
Thank you, Mr. Davis.
Thank you, Stephen. My lady, can I then just give you at this stage the reference? It is Darumpel, DHARU Transport Proprietary Limited versus Darumpel, 1956, Volume 1, SA 700, Appeal Corp, then A, now SCA. In particular, I should just like to refer you to page. Lady, forgive me, I'm old-fashioned. I would prefer to go to the Juda because I can't read the printing. At page 706 of the South African Law Report reference, which I've given your ladyship, His Lordship Justice Hoekster says the following opposite the letter D. The main purpose of the exception that a declaration discloses no cause of action is to avoid the leading of unnecessary evidence. That purpose cannot be served by taking exception to a declaration on the ground that it does not support one case. For instance, the upholding of the exception that the declaration does not support a minor claim would make no difference whatever to the evidence to be led at the trial. All the averments in the declaration would have to be proved by evidence in order to establish the major claim. Even assuming that the declaration does not support the minor claim, I cannot see in what way the defendant will be embarrassed in pleading in view of the fact that it is bound to plead to the declaration as framed in order to meet the major claim. The legal point raised by the exception can be argued at the trial. If there are indeed circumstances which would make it more convenient that this point should be decided before evidence is led, the defendant could apply to the court in terms of the then Rule 59 for an order directing that the question of law to be decided before evidence is led. Now, my lady, no criticism of the excipients, But there is a shotgun approach here. And if your ladyship were to find, for instance, that the pleadings relating to non-compliance with the Constitution and the subordinate legislation on any interpretation is sufficient for the purposes of exception, no purpose would be served with respect, even if your ladyship were to find there's any vagueness or embarrassment in the common law allegations in striking them down, because the evidence will still have to be led. So we suggest, with respect that Dalrymple clearly makes it clear that a court will not strike down one claim from the same cause of action. And here the cause of action, we say, is clearly wasteful, fruitless expenditure. Lady, I was taking your ladyship through the particulars of claim, showing your ladyship that all of these claims are in the alternative, and that is also apparent from 085-34. You will see, if I may just dwell on this for a second, at para 78, we say Killian failed in his duties or failed to prevent financial loss to the department in the amount of that by failing to ensure the effective financial management, and becoming aware of the breach to immediately report the breach to the provincial treasury. Alternatively, we cite section 57. Bear in mind, Killian, of course, was the chief accounting officer. Financial officer. Sorry, the financial officer. And so he had special responsibilities. And we actually cite the PFMA, and then at page 81, paragraph 81, page 085-30, about Legolian, 81.2, it's again in the alternative. 81.3 is further alternatively, and then in 8.4, 5, 6, there are alternative allegations. And then 36-36, there is yet another, and you will see that of the position by the duty of care to not act unlawfully in the manner above and cause damage to the department, alternatively the municipality. Further, alternatively, and before I come to claim 4, I need just to point this out. Mr. Davies made something of the fact that the loss here is alleged to be that of the department. And he said, well, how do Schmal and Killian even fit into this, because they're not employed by the department? But what he forgets is Annexure G. Annexure G is the directive which we plead. We plead it at I just want to point out, milady, I did refer to it earlier. Annexure G is to be found at 035.1-83. And this is the ministerial directive which we have pleaded in the particulars of claim. And the minister says Following the concerns raised by Guyani residents, etc., the directive includes assessing borehole supplementing. She will be establishing a political steering committee, and she says, please find the attached directive to LNW on emergency intervention on water and sanitation challenges in Mopani. And the directive is then attached. Now, the directive went out to obviously, forget about Mr. Lachordi, but to Kilian and to Schmal to ensure, and you will see that the directive was in terms of section 41, little 1b. No, sorry, 41.1 little Roman 2. The minister may, to the extent, this is the Water Act, Water Services Act, which we have cited. The minister may, to the extent that it is reasonable, from time to time issue directives to a water board to undertake a specific activity against full or partial payment as directed by the minister. So that is how we say Mrs. Kilian and Schmal, again, ignored any procurement activities or procurement procedure and simply appointed. Although the loss was incurred by the department, if we are correct, and you must assume our facts are true, because that's what one does in exceptions, if they caused the fruitless and wasteful expenditure, we're entitled to claim it back on behalf of the department. It was their negligence, and the causality, we say, is clear on pleadings. We haven't proven it. I might add, my lady, at this stage, if my learned friend, I think it was a slip of the tongue, suggested that we hadn't pleaded the facta probantia. Just to assist my learned friend's pronunciation, facta probantia are those facts which actually establish the facta probanda. And you only plead the facta probanda. And if the facta probanda is a conclusion, so be it. You acted recklessly. You acted, you wasted money fruitlessly, wastefully. That is the facta probanda. How you prove the facta probantia is for the trial. And it is quite clear on all the authorities dealing with exceptions, which we have cited, that you need not plead the facta probantia. And it is that which my learned friend keeps harping on. He says it's a conclusion. A conclusion, if it's good in law, is sufficient to defeat an exception. It must be accepted at exception stage. It's dark. Yes, I think that claim 4, insofar as it is against the third defendant, I've dealt with. It's the same principle, but the Mr. Kilian was responsible to ensure the management of the finances and cause the damage to the department, or alternatively the municipality. And then the conclusions are important at pages 40 and following. here we bring the threads together, my lady. And again, my learned friend, I don't think read through these. It's 085-40. First defendant we don't need to bother about, but we plead each of them. The third defendant we plead at page 42. That is 085-42. And you'll see that 96.1, we invoke section 57. Milady, I'm sorry, is your ladyship still?
Yes, yes, I'm here.
I'm so sorry, the video has frozen, but as long as your ladyship can hear me, I can switch off our video. I don't know, but I'm almost finished, milady. And then at 523 failed in his fiduciary duties as the account authority. And sections 50, 76 and 83. It is as well to have some terms. I'll read it to your ladyship. Section 83, my learned friend didn't touch on this, but you will find it pleaded in these particulars of claim in a number of paragraphs. 83 says financial misconduct by accounting authorities and officials of public entities. The accounting authority for a public entity commits an act of financial misconduct if that accounting authority willfully or negligently fails to comply with the requirement of a number of sections, and B, makes or permits an irregular expenditure or a fruitless and wasteful expenditure. So, and then there are subsections. So, in the very act, this is the PFMA, which we have pleaded, it creates bullion liability, albeit by statute, should it be found that an accounting authority, for instance, has acted negligently. We don't have to show willfulness. And that is, of course, what differentiates this case entirely from Trope's case. There was no such statute. There was no PFMA. There was no statute which required accounting authorities to act in a regular manner. So I fail to see how my learned friend can suggest that he is taken by surprise when all he has to do is read the sections. And then claim 5 is more of the same thing. Your ladyship will see we plead the sections. We have alternatives at 085-46, always relying on the statute and then relying on the common law. And then I'll look, for instance, the very last paragraph before the claims, 110. By virtue of the position Schmal occupied, he owed a duty of care to not act unlawfully in the manner pleaded above and cause damage to the department. Milady, this exception is not well taken. Sorry, is your ladyship still hearing me?
Yes, yes, I can hear you.
Sorry, your ladyship disappeared there for a moment. Milady, just repeat that last sentence. This is not well taken. The the defendants, Schmal and Killian, Mrs. Schmal and Killian, able to agree to this, without any difficulty whatever. All they have to do is to read the sections we plead. Lady, I don't know if I fit it.
Thank you, Mr. Cochran. Thank you.
Thank you, my lady.
Mr. Davis.
May it please the court, my lady. Does my lady hear me?
Yes, I can hear you.
Good. Thank you. My lady, the distinctions drawn by my learned friend seeking to distinguish Trope and the Archdoppel case, these, with respect, cannot fly, because those cases are not dealing with or are not cited in support of the duties of public officials, but rather the duties of party pleading damages. That principle cannot be escaped by my learned friend. He cannot distinguish between delictual damages and statutory. In either event, the pleader is entitled to the information so as to assess the claim. So now we need the information, and the information is not forthcoming, and we are prejudiced by that. The prejudice I will deal with in a moment, but especially the degree of clarity that is aspect of pleading also points out the prejudice. Now, if I can just return to the particulars of claim and the documentation which we are ostensibly supposed to consult with our client about in order to understand what his defense might be. Now, so section C of the particulars of claim, which starts at 85-7, offends against what I have quoted from Trope and the Archdoppel, particularity in the sense that it refers to sections. And here we have a constitution, albeit section 1, chapter 6 and 10 and 76, and with the Government Gazette. And then we have another one. And then we have the entire Water Services Act. And this is repeated in throughout the particulars of claim. The our lady pointed out, the Constitution sets out in aspirational and transformative terms the goals of public procurement. It is insufficient to say that these are the goals. It is required to say, in respect of the Constitution, where did we go wrong? In my learned friend mentioned section 57. Well, there are at least the PPPFA is meaningless. It just refers to the Constitution. Modified provisions. What part of Regulation 16A? This is a substantial document. The Treasury practiced that to grips with. What we are entitled to know is what did we do wrong in terms of that particular statute? Where does our conduct not square with the statute, and why? or at least what are the facts underlying it. And that I respectfully reiterate is inadequate. While I remember my learned friend relied on the case of Dalrymple transport, I respectfully submit that the case is very clearly distinguishable, because here we are talking about contradictions. And this is the context in which it was raised, that where there's a contradiction, it doesn't matter if it's if it's part of one claim or if it arises in a different claim, so long as if it's not pleaded in the alternative, the light was red, alternatively it was green, the contradiction results in the particulars of claim being vague and embarrassing. And there is even ambiguity can have that result, but contradiction a fortiori must have that result. In Dalrymple, there was no complaint as to vagueness, as to damages or anything like that. It is respectfully submitted that the decision is completely out of kilter with what was stated in Trope and in the potato case, but more importantly, and here I must say, I am somewhat embarrassed in that I'm surprised at the argument, because to the very best of my knowledge, it is permissible to take an exception against an alternative claim. And if one thinks about it, my lady, it's actually ridiculous to suggest that where you have alternatives, if your main claim is good, then your alternatives for a little bit less, cannot be attacked because the main claim is fine. It really doesn't make sense. So, my lady, there is I feel a need for to just advance the authorities to the effect that you can take an exception against an alternative claim, and that I would respectfully ask my commission. It would just be a case or two. As far as I know, it would be easily accessible. As far as I know, it is tried. If subject to my learned friend's input, I could be permitted to provide the case law that explains that you can take an exception against an alternative claim. I respectfully submit that puts to bed the 1956 judgment of Dalrymple.
Mr. Pakran?
Sorry, my lady. Yes, I'm now.
Do you have any objection to the proposal?
Lady, I'm afraid that I lost some sound for a few minutes. Is it a proposal by Mr. Davies?
Yes, please repeat it, Mr. Davies.
Indeed. I was a bit taken aback at the interpretation placed on Dalrymple that you can't take or that seems to suggest that if a main claim is fine, then the deficiencies in a minor claim are not acceptable. As far as I know, Mr. Pakran, the principle, the tried principle, as I understand it, is that you can accept against an alternative claim. And my request was that I be allowed to send to the learned judge a case that shows that or is authority for the principle that you can accept to an alternative claim.
Lady, anything to assist your ladyship. I'm not going to be obstructive. I would simply ask if I can do a half a page in answer to whatever Mr. Davies should send to you within a day.
Yeah, Mr. Dave, thank you, Mr. Puckrin. Mr. Davis, don't just send the case, also do supplementary heads, just half a page, setting out why you submit the case supports the contention that you're making.
Good. I'm indebted to my learned friend and to Milady. Milady, that was Dalrymple, and I respectfully suggest that my learned friend of necessity seeks to extend the reach of Dalrymple to impermissible pastures where he seeks to protect a main claim despite deficiencies in minor claims. I submit that that is not the case. My lady, it was mentioned the Latin phrase qui facet per alium facet per se, which I understand to mean what is done through another's agency is effectively your own conduct, where you cause someone to commit a breach or act unlawfully, as my learned friend explained. But here we have a problem that nowhere do we see any allegations that that either the first or the second excipient were acting at somebody's behest or in collusion or as a joint tortfeasor. There is absolutely no suggestion of that. My learned friend, in the course of his argument, spoke about procuring people to perform an illegal act with the knowledge that it would be acted upon. But again, that brings me back to the essential point. You know, if you are being sued for doing a motivation, then you must also plead why it amounts to a misrepresentation, knowingly false with the intention that it will be acted upon, and the usual allegations as to negligent or fraudulent misrepresentation must be present. But however, we have no such allegation, and I think it is necessary for the SIU to consider factually, is that an allegation that they believe or that it's part of their case, because it is not in their particulars of claim, and it is a fundamental part of the case. So yet another reason for, as our Afrikaans friends would say, fatoeris, take a dead rest and think it through carefully and put forward the SIU's case with clarity and more importantly, with a particularity that is required. On the subject of the motivation, my learned friend again seeks to move to a legal conclusion without the intermediate factual basis. Now, just to use that motivation story as a claim one as an example, it's alleged. My learned friend said that it was clearly not compliant with the Constitution, with the PFMA, with various chapters of various publications here and there. It's not compliant. Okay, even if we accepted that, so what? As I believe Lord Acton once said in respect of evidence on the nature of a contract, so what? But why does it amount to damages? It is not alleged, my lady, that the motivation caused was the direct and natural, or the damages were the direct and natural result of the infringement or the breach or the unlawful conduct. So we have a massive causation issue as well as the problem with the damages. If I can then turn to the...
Mr. Davis, remember, this is a legality review. The legality review. It's not a claim based on contract. It's not a claim based on delict. It is a legality review.
Well, perhaps a different way of phrasing that would say be a legality action. But be that as it may.
Yes, it's a legality review brought by way of action.
Okay. Please excuse my ignorance. My lady, but the same principle applies. That there was a motivation, yes, but the motivation needed to be assessed. The motivation itself does not cause damages. Somebody accepted the motivation. Somebody made a motivation a policy. In terms of a motivation, that must be assessed by the decision maker and acted upon accordingly. The mere fact that the motivation initially, which, as we know from the beginning introductory portions of the of the particulars of claim, it emanated from the minister herself. The motivation cannot be held as the root cause of any damages or however one wants to phrase it. In the particulars of claim, they are referred to as damages. Now, why would a motivation give rise to damages? It simply doesn't. Especially not in the context of this case. The damages, as appears from the particulars of claim viewed as a whole, the damages came from LTE and the subcontractors who were overbilling. It seems that there was the approval of a contract price in excess of the originally awarded or authorized 90 million. But if I can just return to that, the very fact that it was that the request for the 91 million was authorized immediately raises a question over the legality argument. If it was authorized, how can it be illegal? Because that authorization stands, and we know that all administrative action is valid until it is set aside. So there was an authorization. Where is the illegality in the motivation itself, and where is the causal relationship between any damages as claimed? Because we can call it a legality review or legality action or anything. It uses the words damages and it uses the Quillian language all the time. And one way and another, there has to be a link between the motivation and the damages, whereas authorization breaks any causation, because if there was bad authorization, then that is where the legality problem comes in. In the meantime, in terms of the Oderkral principle, the motivation is valid until set aside, and the authorization is valid until set aside. In this case, the authorization has not been impugned in any way, I point out. So we're sitting with a valid authorization for 90 million. A moment, please, my lady, while I try and decipher my handwriting here. My learned friend, dealing with trope, focused his argument on the aspect of wrongfulness, and as I believe I have pointed out, the case is cited in relation to the problems relating to damages and the particularity that is required and the prejudice that flows from the lack of particularity. Likewise, Potato Board also is about the simply not sufficient particularity that we've been bestowed with in these particulars of claim. And I would venture to say that whether we're dealing with a legality review or a delect or some claims that are the one and others that are the other and the alternative, still the fact remains that the excipient is entitled to particularity, whatever the cause of action. And I don't see any grounds for a lesser standard to be applied in legality reviews and
Do you have anything further, Mr. Davis?
A moment, please, my lady. As I said, my handwriting, it seems I should rather have become a doctor. The problem with claim 4 again is the particularity, and I perhaps should have mentioned in greater detail just the throwaway claim 5. It really doesn't seem to have enjoyed the attention that it deserves. The same thing can be said for claim 4. But claim 5 at 85-45, paragraph 102 of the particulars of claim. Here we are dealing with LNW charged the department a management fee. Okay. 103, is my lady with me?
Yes.
103, had it not been for the actions or omissions of the first, second, and third defendants, as set out herein before. Now, my lady, which actions in the preceding 44 pages of particulars of claim justify the conclusion that the department would not have paid LNW implementation fees? So the essential allegation is that at 104, the amount paid to LNW is irregular expenditure. Now, this brings us back to our previous argument concerning facta probanda versus facta probantia. Now, the $1 million question here is, the allegation is made it's irregular expenditure. Now, we are talking specifically about the management fees. Why is it irregular expenditure? Certainly somebody at LNW, or I beg your pardon, somebody at the department considered it to be perfectly regular and therefore paid it. But in the absence of irregular expenditure as identified, as it is incumbent upon the SIU to identify the grounds of illegality. Why is this an irregular? And again, I need take it no further, milady, than the trite principles of the Yanuku versus the Apollo Club, and as endorsed also then in Trope. We are entitled to know why, on what statutory grounds is this an irregular expenditure.
Okay, do you have anything further? You are simply rehashing your argument, Mr. Davis.
I beg your pardon. I was under the impression that I hadn't mentioned Claim 5. I would like to mention costs, if I may, milady. Milady, the stance of the excipients is that this hearing today could easily have been avoided. The plaintiff has dug in its heels in a recalcitrant manner when a timely and appropriate reaction to the exception could have completely made this hearing unnecessary. Even on Mr. Pakran's own admission, the pleadings do not say what they intend. It's not a typo, it's a repeated mistake of express wording. And that can't simply be wished away. The court will have a look at the express meaning, and that will be the meaning accorded to the particulars of claim. Litigants are not expected to read particulars of claim and then decide they mean something else. Litigants are entitled to take the point, and the important point is the contradiction is it contradicts the entire. If we're going to look at the particulars of claim as a whole, as we are encouraged to do by Mr. Pakran, then we see that all those alternatives cannot stand. And if I'm correct that an alternative claim can be the subject of an exception, then on Mr. Pakran's own admission, the exceptions against those alternative claims must be upheld. My lady, the point is that that this litigation could have been avoided. It's simply a question, having been guilty for so long of pleading imperfectly, the plaintiff really should have taken the trouble to ensure that the pleadings are logically consistent, that there are no repeated contradictions as the but-for contradictions, as I've referred to them, that where conduct is alleged to breach a particular standing order, that order must be specified. Where regulations are referred to, the sub-provisions must be referred to. Where a statute is referred to, the provision must be referred to, and that is clear from the authorities that I've cited. Nowhere will there be any indication that reference to a chapter or to an act is sufficient to enable the counterparty to plead. My lady, I respectfully submit that the particulars of claim exhibit an insouciance or lack of attention to detail or lack of commitment to the honourable court, as should attract a jaundiced reaction from the court. We don't need to be here. The excipient needs to be here on account of the prejudice that is clear as per Trope and Artloppel case. However, the plaintiff could so easily have just made the necessary adjustments. They have all the facts at their fingertips, as is very clear from their own particulars of claim. But they just didn't bother, and instead caused unnecessary litigation. And in terms of the authorities which I've cited in my heads of argument pertaining to costs, That in itself, we don't have to look at subjective intention. I'm not for a moment suggesting that there was any subjective intention, but the objective effect of this litigation must be looked at, and I respectfully submit that it justifies an award of costs on an attorney-client scale, such costs to include the costs of two counsel. Those are my submissions, my lady. Are there any aspects upon which I can engage, my lady?
Nothing further from me. By when are you submitting the case and the supplementary heads?
My lady, can I press for Monday? I have an intense week coming up. I'm in your hands. My lady has imposed the timetables as you deem fit, and I'm not going to change that.
Monday is fine, Mr. Parkerin. Will you submit by Tuesday?
Submit by Tuesday, my lady.
Okay, thank you. It's adjourned and judgment is reserved. Thank you very much for your assistance.
May it please the lady.
May it please the court.